Washington Journal continues.
Steve Hoersting is the co-founder and vice president for the Center for Competitive Politics, and Jamin Reskin is the constitutional law professor at American University Washington Law School, joining us this morning to talk about this court ruling yesterday, 5-4. Mr. Hoersting, let me begin with you, if I could.
Well, I think if you were to check the Wall Street Journal editorial, you would see that this is a victory for free speech and the First Amendment. Diving right into the corporate governance issue, it's true that if Congress and states and municipalities want to change the way corporations are governed under their state laws, that's possible, and they can certainly provide more remedies or rights for minority shareholders who think that perhaps this candidate shouldn't be supported or maybe this candidate shouldn't be supported. But at the end of the day, the Supreme Court of the United States rejected that rationale as a basis for banning speech, which is really the issue we have here.
Mr. Hoersting referred to the Wall Street Journal editorial. Let me show it to our viewers. A free speech landmark is how their take on it this morning. But let me also show USA Today's opposing view this morning, written by your colleague, Bradley Smith, who says that this argument that there'll be floodgates of corporate money is pure science fiction. He says this, that first, the case does not alter the current ban in federal law and the laws of just under half the states that prohibit corporations and unions from contributing directly to candidates. All this means is that they can spend money to speak directly to voters. He also points that 28 states, including 60% of the nation's population, already allow corporate and union independent expenditures in state races. Yet none of these states are swamped with corporate and union spending.
We're talking about a fundamental transformation of the character of American political democracy. So I think that we clearly need a constitutional amendment to declare that a corporation is what the Supreme Court had always said it was up until yesterday, a creature of the state legislatures. Corporations are set up by the public, by the state legislatures for our economic purposes, to accumulate wealth, to generate wealth. But as Chief Justice Rehnquist said, the court has always understood there are special dangers attendant to allowing the creature of the state to turn around and to get involved in politics.
I couldn't disagree more. First of all, let's get back to first principles. This is a tremendous opinion. The Supreme Court has essentially said, no matter what your organizational form, you as a citizen, as an organization, you are a person, you have the ability to participate independently in political campaigns, and you don't have to buy a newspaper like the New York Times to do so, and you don't need to own a broadcast station like Fox News to talk about campaigns and politics. This opinion restores First Amendment footing, even for organizations like C-SPAN, because very few people understand that the government's position in this case was that it could ban corporate-funded speech, and the only thing that prevented that from reaching media corporations was one exemption by Congress that it could have removed at any time. With this opinion, media corporations have restored their First Amendment rights to speak about campaigns and politics, and the court said if a media corporation may do so, all corporate entities and labor unions may do so.
But let's be clear about that. The Constitution guarantees the freedom of the press. Nothing in McCain-Feingold ever attempted to restrict what media entities do, and the Congress has never attempted to do it.
Of course, there is a right of the press to engage under the First Amendment in politics, in speech of any kind. But the press, Jamie, is an activity. It's not a class of individuals or actors or a class of participants in our society. It is an activity. If the First Amendment were written today, it would have in it freedom of the internet. But there's no such people with internet in their hat bands walking around saying, I'm the internet.
Let me just show you a headline this morning in the Financial Times. Court's campaign finance ruling raises fear lobbyists will cash in. And before I read that, though, I want to show the New York Times headline on this. It says, lobbies' new power, cross us, and our cash will bury you. It's below the fold here, right in the New York Times. And let's put that up on the screen for the viewers. And then let me read a little bit from the Financial Times. It says, before the Supreme Court ruling, a company could dip into its Political Action Committee fund, a regulated pool raised from individual employee contributions, and donate $5,000 to a lawmaker's opponent. Now they can run $5 million or $50 million in television advertising attacking the member in the member's district. This is from Trevor Potter, who was former general counsel to the Republican Senator John McCain's 2008 presidential campaign. Your
I'm
response.
familiar with Mr. Potter. Yeah, the idea that lobbyists' power will increase significantly under this provision, I think, is fundamentally flawed. Here's why. Right now, you have large corporations that avail themselves of lobbying. It is the mid-list corporations who are being left out in the cold prior to yesterday's opinion. Here's why. Everyone talks about bailouts for AIG or Bank of America or these other financial firms, but no one, the Treasury Department is not wondering what AIG thinks about any of its policies. Bank of America, I am sure, is speaking with Treasury Department and has lobbyists on Capitol Hill daily, if not hourly. So they will always have their connections to the Hill. It is the mid-list corporations and the smaller nonprofit corporations that, under the political committee restrictions of the very law you favor, can't get the PAC together because they can't afford the administrative costs. And if they could, they don't have enough people in their organization to adequately fund the PAC to make it viable. The facts of this case were a nonprofit corporation named Citizens United wanted to run a movie. They created a documentary film called Hillary the Movie. They distributed it on DVD, they put it in movie theaters, and then they decided, let's put it on cable for video on demand. And this is where they ran headlong into McCain-Feingold, because McCain-Feingold says that any communication that mentions a candidate over broadcast, satellite, or cable within 30 days of a primary election can be banned if it's run by a corporation or a union. Now, this documentary by Citizens United was actually banned, and it was not permitted. So the Supreme Court, when they finally got the case, asked the government, so we understand it's your position that you may ban movies. Let me ask you, is it also your position that you may ban books? And the federal government answered what many people who practice in this area realize, but the Supreme Court hadn't thought about. He said, yes, if a book says vote for or vote against a candidate and it's paid for by a corporation, which all of them are, Simon & Schuster is incorporated, then the government claims the right to ban that book. I think it's fair to say that that answer shocked the Supreme Court, and they immediately asked for additional briefs from all parties and a second round of oral argument, which is very rare for the Supreme Court to do. Now, if I can for a moment, speak about rent-seeking and trusts. Jamie keeps talking about the idea that you'll have these large corporations, and they won't speak in opposition to each other. They'll all collude and get together. Well, here's the thing. This opinion allows entities to speak to the citizens about who should and who should not be elected. There's an intervening factor that everyone's forgetting here, which is the voters. You can spend train loads of money promoting a candidate. At the end of the day, people have to decide, will they vote for him or her, or will they not? Let's take the Corzine example out of New Jersey. He spent $24 million on his gubernatorial race, largely his own cash. His opponent spent $8 million. Corzine lost that race. He lost it, decidedly, and he outspent his opponent 3-1. So this idea that money spent determines who wins is wrong because there's an intervening action, and that's voters who decide, do I agree with that speech I heard, which was loud and frequent, or do I disagree with it?